The Assembly Committee on Government Affairs will come to order. Madam Secretary, please call roll.
Assemblywoman Anderson. Assemblywoman Black. Assemblywoman Brown May. Assemblywoman Considine. Assemblywoman Dickman. Assemblyman Ellison. Assemblywoman Duran. Assemblywoman Martinez. Assemblyman Matthews. Assemblyman MacArthur. Assemblywoman Thomas. Assemblywoman Torres. Chair Flores.
Here. Thank you, Madam Secretary. Please let the record reflect Assemblyman Ellison is absent excused. We do have a quorum. Good morning, members. I want to remind everybody to please make sure your cell phones are on silent, that you are not logged in on Zoom and in the committee room at the same time. We're going to take the agenda out of order. We'll be doing Senate Bill 294 first, followed by Senate Bill 253. I want to remind everybody wishing to testify this morning to please state your name for the record, and that the first time you speak, make sure you spell your name for the record so that we can help our staff who's working behind the scenes. For those of you wishing to participate in public comment, we'll be doing that at the conclusion of today's hearing. And with that, I'd like to open up the hearing on Senate Bill 294, and we have our Majority Leader Canizaro here. Good morning, welcome, whenever you're ready.
Good morning, Chair Flores and committee members. It is again an honor to be here with all of you this morning. I am Nicole Canizaro. I represent Senate District 6 in the northwest portion of the Las Vegas Valley, and I'm here today to introduce to you Senate Bill 294, which makes revisions regarding collective bargaining between local government employers and employee organizations. Joining me today, Chair, is Fred Horvath, who is the Treasurer for Teamsters Local 14. And with your permission, Chair, I would like to give some brief opening remarks and a brief walkthrough of the bill before turning it over to Mr. Horvath for his presentation.
Please.
Thank you, Chair. So by way of background, currently, if an organization that represents local government employees, other than educational support personnel, firefighters, police officers, and teachers, fails to resolve an issue in negotiating a collective bargaining agreement with an employer, the dispute can be submitted to an impartial fact finder. However, before doing so, the parties need to agree to make the recommendations of the fact finder on certain issues final and binding. When the local government employer and employee organization cannot agree, either party may request the formation of a panel to determine whether the findings and recommendations of the fact finder on certain issues will be final and binding. This bill repeals the provisions relating to those panels and instead provides that the parties may agree to make the findings and recommendations of a fact finder final and binding and may submit those findings to a second fact finder to serve as an arbitrator. Currently, the process for police, fire, educational support personnel, and teachers in local government is different from other local government entities, and this bill seeks to create some parity among those groups. I would note for members of the committee that I did submit a mock-up amendment to Senate Bill 294, which I believe was made available on NOS, and I'm hoping that everybody has had a chance to take a look at. It does make one small change with respect to the process for some of these provisions. A brief overview of the substantive portions of the bill I'd like to discuss at this point. Sections 1.5 and to repeal the provisions relating to those aforementioned panels that I discussed briefly. And Section 1.5 further provides that the fact finder shall make findings in his or her written report. Section 2 clarifies the provisions applied to labor disputes other than police, fire, teachers, and educational support personnel. In addition, Section 2 outlines that the parties may agree to make the findings and recommendations of a fact finder final and binding, and that either party may submit those findings and recommendations to that second arbitrator. If the decision is submitted to a second fact finder, that decision would be final and binding on the parties. Section 2 further provides for the process to select the fact finder. In the amendment submitted to the committee, Section 2 also provides that the procedure for an arbitration is subject to the provisions of NRS 288.215. Section 4 eliminates the authorization for expenditure of funds for expenses related to those panels. At this time, Mr. Chair, what I would like to do is introduce Mr. Horvath, who has a brief presentation for the committee.
Good morning and welcome. Is your microphone on?
How about that?
Thank you.
I didn't know you did that. All right, my name is Fred Horvath. It's H-O-R-V as in Victor, A-T-H, and I'm the Secretary Treasurer of Teamsters Local 14. Just like to provide a brief presentation, if that will work for you, and then just walk you through. So 288 is the collective bargaining law in the state. It's managed by the Employee Management Relations Board. And employee organizations must provide notice to local governments by February 1st of a given year if they are interested in bargaining something that involves monetary budgeting. So a quick look at the process is exchange proposals, negotiate, tentative agreement is reached, ratification process by the employee organization, ratification of an agreement by local government board, council, commission, or the state board of examiners, and then a public hearing to address the financial impacts and the contents of that agreement. Impasse process is the reason we're here, and the impasse process within 288 is mediation first, and it's got prescribed timeframes to keep the process moving along. Fact-finding follows mediation. There's very specific statutory requirements that the fact finder must follow, specifically to ability to pay, establishing that first. If the fact finder determines that there is no ability to pay, the process gets abbreviated very quickly. And the parties can agree, under the law, to make the fact finder's recommendations final and binding to avoid the potential of arbitration. You can just use that process to bring this to closure. So the current employee organizations under NRS 288 that have a binding arbitration statutory right are police and firefighters under 288, 215. Under 217, it's teachers and support professionals, and then with collective bargaining in the last session, state employees have access to final and binding arbitration. And that leaves everyone else, and we represent a lot of those people in Southern Nevada. So 288-201 is the process for a panel. And the panel is an interesting challenge, and I'm going to defer to Commissioner Snyder, who I think will be speaking to you later about the challenges it creates for him and his organization. But the panel is one attorney, one person who's an accountant from the State Board of Accountancy, and the two of them then pick a third person to be the group that will decide which parts of the fact finder's decision should be final and binding. Maybe. There's really no statutory requirement for them to actually make any decision whatsoever, which creates its own set of challenges. And this is a very time-consuming process and does not bring collective bargaining to closure in any way, shape, or form, similar to what's in the statute around binding arbitration. Very specific dates and timeframes for results. So the EMRB commissioner is the chair of this panel, and Senate Bill 294 eliminates this separate process. It provides for one consistent process for all employee organizations. It provides the same statutory standards for fact finders and arbitrations for all groups. And it allows employee organizations, local governments to agree to make certain, and this is a tweak for the people we represent, you can agree in advance that if you have 6 issues that are going in front of the fact finder, you can agree in advance that these three we will accept as final and binding. The other 3 will take under advisement and could go to the arbitrator. That provision doesn't apply, and that change does not apply to police and fire or teachers and support staff or obviously the state employees. That's just a sprint through the process and what Senate Bill 294 attempts to achieve. Be happy to answer any questions you may have.
Thank you for
Thank
the,
you.
for the presentation, appreciate that, and thank you for walking us through that. We'll open it up for questions, but prior to doing that, if we could just, one more time, have you go through the amendment, just so that we can make sure that there's an understanding by the committee members exactly what
Yeah,
I did.
thank you for that, Chairman Flores. The amendment just provides absolute clarity that the process for arbitration will follow the language in 288, 215, and specifically sections 8 through 13. And that is the selection of an arbitrator, what's in front of the arbitrator, that there are last, best, and final options put in front of the arbitrator from each party, and the arbitrator must select one of those. So it just provides complete clarity that we're not asking for a different process. We're just going to follow exactly what police and fire do when it comes to the arbitration process.
And thank you for that. At this time, we'll go to questions, members. I'm going through the chat. And I don't see anything there, so I'll start off with Assemblyman MacArthur.
Thank you, Mr. Chairman. Fact finder in here, an awful lot. How do we find the fact finder? How do you get a fact finder? Who is it?
Great question. So through you, Chair Flores, to you, Assemblyman, there's a very clear language that we get a list of 7.
I apologize for interrupting you. If I could just have you state your name for the record, please.
Okay, I'm sorry. Fred Horvath, for the record. There's very clear language in 288 that says there's a list of 7 fact finders or arbitrators. It's the same, and actually there's a list of mediators prescribed in the Act. And you get that list from the Federal Mediation and Conciliation Service or the American Arbitration Association, one or the other. And then the parties just strike, alternating strike till they get to the final name. It's prescribed in 288.
But how did we get those people into those organizations?
Oh, they're mostly attorneys, and they just make application to the FMCS and AAA, as we call it, American Arbitration Association, to be listed on the panel. One of the important things that the parties look for is experience in interest arbitration, which is the arbitration for the end of a collective bargaining agreement, which involves local government finances. There are lots and lots of arbitrators who do disciplinary processes, contract interpretation, but we're really looking for someone who has specific experience, local government finances, ability to pay, those type of provisions, and so you're always looking for that in the qualifications.
Thank you.
Great, thank you, Assemblyman. Next, we'll go to Assemblywoman Thomas.
Good morning, Chair, and thank you for this opportunity to ask questions on SB 294. And I appreciate Senator Casanaro for bringing this forward, and to you, Mr. Horvath. My question actually is just for you to let the panel know, the committee know right now, that when you are picking a fact finder, both sides have an opportunity to, just like you're picking a jury. So, and they can disqualify for whatever reason, and then they come down to that one person that they want. I just want you just to explain that so that all of us know. Thank you.
Thank you for that question. Fred Horvath, for the record. Assemblywoman Thomas, that's really the most important piece of it is that we are given a list of names, and I would say the biographies and experience are 5 to 6 pages long, detailed decisions that have been made. And both parties, the local government employers, and I did that for 11 years at the City of Henderson, representing the management side of it. And so it's really an important piece to do your homework, but then it's very much a strike process where you eliminate the person that you want to see first off the list, local government would go next, and you just continue down to the bottom of the list. And I've seen situations where the parties agree that there isn't someone on this list that they're comfortable with, and they can ask for a new list.
Thank you. And Chair, follow-up, please?
Please follow up.
Okay, and my crux of my question today would be, I want to make sure that I understand that SB 294 wants to restore binding arbitration with, so that we have the same opportunity as, and I say we, that local entities have the same opportunity as police, firefighters, state employees when it comes to binding arbitration.
Fred Horvath, for the record, to you, Chairman Flores, to Assemblywoman Thomas. I wish it was restore, but in fact, this group has never, since the creation of 288 in 1967, has never had binding arbitration. They've always had this panel process, which has been used sparingly just because of the time it takes and the potential ambiguities in what that panel actually can do. So this would be the first time to get everyone on the same page under 288 relative to binding arbitration.
Thank you, sir.
Thank you.
I appreciate that explanation. And thank you, Chair.
Thank you, Assemblywoman. Members, any additional questions? Seeing none, thank you for your
Thank you.
presentation
Thank you so
again
much.
this morning. At this time, we'll go to those wishing to testify in support of Senate Bill 294, and we'll start with those who are present here in the room, please. Good morning and welcome.
Good morning, Chairman Flores and members of the committee. Nicole Rourke. I'm the Director of Government and Public Affairs for the City of Henderson, and I really appreciate working with Senator Cannizzaro, Mr. Horvath on this bill. We support SB 294 as amended by proposed Amendment 3351. This amendment will apply the same processes used by public safety members when they are unable to reach an agreement after negotiations with their employer as to members of Teamsters Local 14. This aligns the process so that everyone knows how it works and what the possible outcomes are. Non-binding fact-finding is a useful next step in negotiations for employers and employee organizations to utilize to obtain a third-party objective opinion regarding matters in which both parties have genuine, though differing, beliefs or opinions. Each party may change its belief or opinion on a certain fact or consequence based on the fact finder's decision. This creates an opportunity for one or both parties to appreciate the other party's proposal in a different light or to agree to a modification or compromise of a contested matter. In other words, non-binding fact-finding is an opportunity to help the parties reach a mutual resolution. Most people would agree that if two sides can reach a mutual agreement, it is better received than a decree that is imposed on the parties by an outsider. However, when resolution cannot be achieved through non-binding fact-finding, the second fact-finder should be required to choose between the best and final offers submitted by one of the parties, as reflected in 288-215. This is how the process works for police and fire, and by adding this reference in Section 2, subsection 6, it will be how it works for other employee unions such as Teamster Local 14 members. Thank you so much.
And thank you. Appreciate you joining us in person. Welcome. Is there anybody else here presently in the room wishing to testify in support of Senate Bill 294? Seeing none, we'll go to the phone lines at this time. Broadcast, please.
To testify in support of Senate Bill 294, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 796, please slowly state and spell your name for the record. You may begin.
Thank you. Thank you, Chair Flores and members of the committee. My name is Rusty McAllister, RUSTYMCALLISTER. I'm the Secretary-Treasurer for the Nevada State AFL-CIO. We're in support of SB 294. We believe that this process, bill will allow the process to be a more fair and equal process that will help speed up the negotiations and hopefully come to a more equitable resolution in a timely fashion. For a long time now, there's been an unequal process that the Teamsters have not been able to access, and this would help clarify and clean that up and make it a more timely manner or timely process to move forward. So with that, Mr. Chairman, we are in support of this bill. Thank you.
And thank you. Broadcast next caller in support of Senate Bill 294.
Caller, with the last three digits of 237, please slowly state and spell your name for the record. You may begin.
Good morning, committee. My name is Marlene Lockhart, Lockard, representing SEIU 1107. We are in full support of this bill and urge your favorable consideration. Thank you so much.
And thank you for joining us this morning. Next caller in support of Senate Bill 294.
Caller, with the last three digits of 863, please slowly state and spell your name for the record. You may begin.
Good morning, Mr. Chair and members of the committee. Dagny Stapleton, D-A-G-N-Y, S-T-A-P-L-E-T-O-N. I am the Executive Director of NACO, the Nevada Association of Counties. We are in support of the bill this morning. We appreciate the changes from the first draft of the bill that the Majority Leader made, as well as the amendment 3351 that is being discussed today. We had actually requested the same change, and so very much appreciate the incorporation of that, that the arbitrator would work off the last best offer in the second fact finding. Again, we appreciate the Majority Leader very much working with local governments on this bill, and we urge your support. Thank you so much.
And thank you for joining us this morning. Next caller in support of Senate Bill 294.
Caller, with the three digits of 837, please slowly state and spell your name for the record. You may begin.
Good morning, Chair Flores, Majority Leader Canizaro, and committee members. This is Kent Irvin, K-E-N-T, E-R-V-I-N, for the Nevada Faculty Alliance, representing faculty at NC colleges and universities. The NFA represents collective bargaining units under NC code at the College of Southern Nevada, Truckee Meadows Community College, and Western Nevada College. In solidarity with our local government union partners, we fully support SB 294 for the reasons that have been stated. Having best and final binding arbitration to settle an impasse is an efficient and rapid way to come to a conclusion in negotiations and is fair to both sides. I would point out that with passage of SB 294, that NC faculty will be the largest group of public employees in the state without this kind of provision in collective bargaining, but we hope to fix that this session with SB 373. Thank you very much.
And thank you for joining us this morning. Next caller in support of Senate Bill 294.
Caller, with the last three digits of 799, please slowly state and spell your name for the record. You may begin.
Good morning, Mr. Chairman and committee members. For the record, Justin Norton, Justin Norton. I am the treasurer of the Washoe County Employees Association, which is a collective bargaining unit in Reno that covers more than 1,500 employees of Washoe County. We, on behalf of the WCEA, we strongly support this bill and the proposed amendment. It really is something that is just about equality and parity with the other collective bargaining associations, to be able to have that sort of binding arbitration, which it basically can be pro-union. It can also come anti-union. So it's not necessarily something that is automatically going to swamp any of the local governments with unexpected expenses or anything like that. It's really just about honoring the contracts that we all agree to with, as on behalf of our employees and on behalf of the local government. So we strongly support this bill and the amendment. Thank you.
And thank you for joining us. Next caller in support of Senate Bill 294.
For the new callers, To testify in support of Senate Bill 294, please press star 9 now to take your place in the queue. Chair, there are no more callers in support at this time.
Thank you. And at this time, we'll go to those wishing to testify in opposition to Senate Bill 294. I don't believe we have anybody present in the room, so we'll go back to the phone lines. Broadcast, please.
To testify in opposition to Senate Bill 294, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. And lastly, we'll move to those wishing to testify in the neutral position on Senate Bill 294. Again, I don't believe we have anybody present in the room, so we'll go back to the phone lines. Broadcast, please.
To testify in the neutral position on Senate Bill 294, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 000, please slowly state and spell your name for the record. You may begin.
Good morning, Chair Flores and committee members. My name is Bruce Snyder. I am the commissioner of a state agency called the Government Employee Management Relations Board, or EMRB, which regulates labor relations between Nevada's governments and the unions that represent their employees. The EMRB is neutral as to whether fact-finding should be binding or non-binding. However, I wish to thank the bill's sponsor for amending the original draft of the bill. The amendment eliminates fact-finding panels, which are a misnomer in that a fact-finding panel does not do any fact-finding. Rather, the sole purpose of a fact-finding panel was to determine whether the upcoming fact-finding will be binding or non-binding when the two parties at impasse cannot agree on this issue. In essence, the purpose of a fact-finding panel is to determine the role of the fact-finder. Impasse resolution proceedings are meant to be timely so that the parties can get to a final contract. However, the fact-finding panel process is anything but that, and that was previously explained in the hearing before the Senate Committee on Government Affairs. For example, the fact-finding members are composed of a member from the State Bar of Nevada and the State Board of Accountancy. Those organizations each must submit 5 names of their members, which is done only after educating them as to why they are involved in a labor dispute. The names are then stricken by the parties at impasse, and only 1 name remains on each list. These 2 chosen members are then contacted by me. Due to conflicts or an unwillingness of a chosen person to serve, often a new list must be requested. Finally, when the 2 members have been finalized, they must then appoint a 3rd member. Only until this is done can the agency then submit a work program to obtain the funds to pay the 3 panel members along with their travel. Then the 3 panel members must register as employees like any other member of a board on the state. This whole process takes at least a couple months. In the meantime, the fact-finding itself is put on hold along with resolution of a new contract. I'm happy to answer any questions the committee might have. Thank you.
And thank you for joining us. I don't believe we have any questions for you, but again, thank you for joining us this morning. We'll continue on the phones with those wishing to testify in the neutral position on Senate Bill 294.
Chair, there are no more callers in the neutral position at this time.
Thank you. Senator, any closing remarks you may have?
Just very briefly, Chair, I wanted to thank you and the committee for taking the time to hear Senate Bill 294, which I really do believe brings some parity and some accountability for local governments and their employees when they are involved in bargaining, and would thankfully urge your support. And again, just thank you for having us this morning.
And thank you again, Senator, for your presentation. With that, we'll go ahead and close out the hearing on Senate Bill 294. And at this time, we'll invite our senator, who I believe is not in the room presently, but I'm sure he'll make his way into the room so that we can open up the hearing on Senate Bill 253. Members, we'll do a quick 1-minute recess just to allow our senator to make his way back into the committee room. 1-minute recess. The Assembly Committee on Government Affairs will come back to order. Good morning, Senator. Welcome back. And at this time, we'll open up the hearing on Senate Bill 253. Whenever you're ready.
Thank you, Mr. Chairman. I apologize about my tardiness. I had to go deal with the matter with the principal. I got in trouble. It happens. In that respect, thank you for hearing Senate Bill 253 this morning. It revises provisions related to alarm systems. And in that respect, what the bill is trying to do is, we have a situation where some municipalities have come forth and put on fines and regulations. And those fines are going to the alarm system company rather than the individual who has violated or caused. Gosh, I can't slow down. I apologize. The bill is seeking to make sure that the individual who causes the alarm to be triggered is the person who would be fined, rather than the alarm company. Because as it stands now, we had situations in Douglas County where that trigger and paying of the alarm company didn't adequately reduce the amount of individuals who got false alarms. In that respect, if I could turn it over to our lineup, and I'll try to catch my breath. Sorry. I've run around too much. I'll turn it over.
Thank you, Senator. And we appreciate you running up to the committee room. Good morning and welcome.
Good morning, Chair Flores, members of the committee. My name is Jimmy Lau. I'm a senior associate with Ferrari Public Affairs, and I'm here representing ADT. So thank you, Senator Settlemyer, for giving a brief overview of what the bill is looking to do. I know in this committee especially, you often don't get bills that are less than 5 sections and especially less than 5 pages. So with that, I'll just continue with a very brief overview and then give you some extrapolations about what this bill does and does not do. So like Senator Settlemyer said, the bill ensures that if a municipality or county chooses to impose a fine for false alarms, that fine is directed towards the individual who is responsible for triggering the false alarm. So with that in mind, I'd like to point out that the bill does not require a municipality or county to impose a fine. That remains within their discretion. So if they choose to do that, this bill is simply giving them the parameters in which they can impose the fine or penalty. This bill does not prohibit alarm companies from being fined if the alarm company is at fault for triggering the false alarm. And some municipalities and counties have chosen to impose other restrictions on alarm companies. This bill does not touch that at all. So that's about all I have for my part of the presentation. So Chair, if you don't mind, I would like to turn it over to Holly Borgman with ADT.
Please. Good morning. Excuse me. Good morning.
Good morning. My name is Holly Borgman, HOLLYBORGMANN, and I am the Vice President of Government Affairs for ADT Security Services. With more than 145 years of industry experience, ADT is the leading provider of electronic security services in the U.S. And on behalf of our 7 million customers and more than 17,000 employees who help save lives for a living, I'd like to thank you for this opportunity to offer our strong support for Senate Bill 253. Well, false alarms are a serious issue for our industry and for the police departments that have to respond to these alarms. So because of that, ADT supports efforts to meaningfully reduce false alarms. And along with our trade associations and industry allies, we routinely work with municipalities to design programs that minimize false alarms. In fact, most cities in America right now have adopted some sort of false alarm management system, which these programs are all locally designed and administered. Each one is a little bit different, and they're meant to encourage proper use of alarm systems. And many of these programs include a provision that allows municipalities to fine users for excessive false alarms. This is because studies have shown that in general, 80% of false alarms are generated by just 20% of the users. Most people never have a false alarm in their home during a year. Finding chronic misusers of false alarms, I want to stress chronic misusers of false alarms, alarm systems can dramatically reduce the number of false alarms. Unfortunately, some municipalities in recent years, in the interest of expediency, have enacted programs that fine the alarm company for the customer's false alarms, as opposed to the user generating the false alarm. The alarm company is then forced to recoup the money from the user. Now, we found that this is the equivalent of sending an individual speeding ticket to General Motors. It does little to change the user behavior, denies the user the right to confront their accuser and access to due process, and fines an innocent party for the actions of another. When cities adopt these types of policies, residents lose their ability to appeal the fine to the city and must instead direct their appeals to private businesses who have no obligation to hear or respond to their appeal. So for instance, if somebody opens a window and then the alarm goes off and the window drops, the person might say there was not a false alarm. If the company is given the fine, then what we do is we pass it on to the user, usually with an administrative fee, and there's no appeals process. The city of Fontana, California adopted such an ordinance years ago, and after many months in court and thousands of dollars spent, the ordinance was overturned and ruled unconstitutional. And while the industry won, our alarm industry, we won in court, our relationships with law enforcement and with city leadership, they were strained tremendously. And little headway was made during that time to actually reduce the number of false alarms. We found that in general, while this may be unconstitutional, most people, when they read the Constitution, don't see the provision that says that you shouldn't fine an alarm company for a customer's false alarm. So it requires some interpretation that generally is not readily apparent. Since then, a number of states, including California, Florida, Georgia, Texas, New Jersey, Tennessee, Iowa, Louisiana, Georgia was just signed yesterday, have enacted similar legislation to guide local governments as they consider how to best address this issue. Senate Bill 253 provides much needed clarification that fines can only be issued to the party at fault for the false alarm. If the user generated the false alarm through misuse of his or her system, the fine would be sent to that person. And if an alarm company installed faulty equipment or did not follow proper protocol, the fine would be sent to the alarm company, as it happens today in Nevada. It doesn't require any municipality in Nevada to change an existing ordinance and does not impose any new fees. It simply preserves the status quo and ensures that any locally administered false alarm reduction program will actually produce meaningful results. In closing, I respectfully ask the committee to vote in favor of Senate Bill 253. Thank you for your time and consideration.
And thank you for joining us this morning. We'll come back to the committee room. Any additional comments, please?
Thank you, Chair. I think that concludes our presentation, and we're available for any questions.
Perfect. At this time, we'll go to questions. Members, any questions? You could just give me a quick nod. We'll start off with Assemblyman Matthews, please.
Thank you, Mr. Chairman. Thank you, Mr. Lau. Thank you, Ms. Bergman. I just wonder if you could speak to what would happen in the event where there's a dispute or a contention, about who really is responsible, whether it's the individual or the company, and how and where and by whom that question of fact is determined. If you could just flesh that out a little bit more. Thank you.
So I'm happy to answer that question if I can. So around the country, every local government deals with this differently, but generally when the police respond to the alarm, they determine, is this something where someone forgot to give the passcode to their sitter, or has the system been going off for a while? And they determine, the police department, when they respond, they determine which party is at fault. And right now they're the ones who determine who would get the fine. So if there is a provision in the local ordinance to fine the alarm company, then the fine is sent to the alarm company. If the provision requires them to send the bill to the user, then it goes to the user. And if there's a dispute, then it's worked out through city appeals.
Thank you. Thank you, Mr. Chair.
Thank you. Members, any additional questions? We'll go next to Assemblywoman Considine.
Thank you, Mr. Chair, and thank you for this bill. So I guess just to follow up on Assemblyman Matthews' question, where right now in Nevada, so the police arrive, the police determine who gets the fine. In Nevada, is there anything that says currently in statute or ordinance that the fine must go to the alarm company, or right now are those fines going to the users?
Thank you, Assemblywoman, for the question. Chair, through you, to you and through you to Assemblywoman Considine. There's nothing currently in statute that would require the fine to go in either direction. So the purpose of this bill is to establish those parameters for the municipalities who may choose to implement fines or penalties for the response to false alarms.
Thank you.
Members, any additional questions? I am checking the chat now, just in case I may have missed somebody. I don't see it. Anyone else? Is that right? Thank you for your presentation this morning. We appreciate it. And at this time, we'll go to those wishing to testify in support. I believe we have somebody here in the room. Good morning. Welcome.
Good morning, Chairman Flores. My name is Terry Taylor. I'm a fire arson investigator, and I represent the Fire Prevention Association of Nevada. It's 200 members, and the State Arson Investigators Association. Senator Settlemeyer contacted me because I had the misfortune of having to write the Douglas County ordinance for false alarms as it related to fire service alarms. And I have investigated numerous companies, individuals working for companies, and situations regarding the proper operation of fire alarms. I'm currently employed by the North Lake Tahoe Fire Protection District in Crystal Bay and Incline Village, and I currently have 5 cases open where we are looking at why we are getting repeated alarms from a certain casino, from a certain restaurant, from 2 condominium projects, and from a beach house. And so this causes our crews and our sheriff's deputies in the area to be woken up. For our crews, they're woken up in the middle of the night. The sheriffs are up all night and respond to these fire alarms. So what I've discovered is that in many cases what we call a false alarm is the alarm system actually working properly. And so it is, in the case of commercial smoke alarms, they will in fact pick up moisture, they'll pick up dust, they'll pick up heat, they'll pick up carbon monoxide with some of the combination systems, and they are in fact doing what they're supposed to do. They're warning occupants that there is a problem, a perceived problem within their technical limitation. Our crews believe these are false alarms. They are, in fact, not false alarms. They are what we refer to as nuisance alarms. And so we have identified time and time again that it is more about the operations going on in the building itself or the lack of turning off an alarm system when there's construction activity rather than the alarm system. Conversely, I have, in fact, investigated alarm system employees. And in Nevada, we have a very strong and strict system that I worked on when I worked for the State Fire Marshal's office. And we are heavily regulated. The individual technicians are licensed. The companies are licensed. The State Fire Marshal under NRS 477 has primary jurisdiction and authority statewide to investigate any issue that arises out of any fire protection system contractor, as well as, in most cases, to the State Contractors Board. And both of these entities have been active in the last 25 years that I've been doing this, and both of them have conducted serious investigations, brought both civil and criminal litigation, as I have, against alarm companies for basically obtaining money under false pretenses and doing other acts like this. But the majority of our nuisance alarm problem is the business people or the homeowners or whatever not following the guidelines in deactivating alarms. And finally, what I'd like to point out is it is very, very difficult, whether it's a burglar alarm or a fire alarm, when the alarm company is doing an annual inspection, let's say, and they say, hey, this is broken, it's worn out, it's out of time, we can't get parts for it, we have to replace it. And the building owner says, well, I'm not going to do that. And those are the kinds of cases that I'm dealing with now up in Lake Tahoe. The building owners are just saying, we've had a miserable year, I don't have the capital to upgrade the system in this particular casino, and so I'm not going to spend the money. So in my view, and in the view of all the fire marshals that I've talked to statewide, we had a pretty vigorous debate about this issue. We feel there is already a sufficient regulatory scheme that can investigate, criminally prosecute, or civilly prosecute against alarm companies, against sprinkler companies, against other fire protection service firms if there's a problem. So that is why we, as a group, I was authorized to come here and support Senator's Settlementer's bill. And if you have any questions, I'm happy to answer them. Otherwise, I wanted you to know that your fire departments and your fire prevention people believe that we have the necessary tools right now, that if we have a problem with an alarm system, we can identify whether the problem belongs on the alarm company side or on the homeowner or property owner side and take appropriate action.
And thank you for bringing that insight. We appreciate it. Members, any questions? Seeing none, again, thank you for providing that insight this morning. We'll continue with those wishing to testify in support of Senate Bill 253. We don't have anybody here in the committee room, so we'll go to the phone lines. Broadcast, please.
To testify in support of Senate Bill 253, please press star 9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thank you. Next, we'll go to those wishing to testify in opposition to Senate Bill 253. We don't have anybody present in the committee room. If we could go back to the phone lines, please.
To testify in opposition to Senate Bill 253, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. And at this time, we'll go to those wishing to testify in the neutral position on Senate Bill 253. Nobody present in the committee room. If we can go back to the phone lines.
To testify in the neutral position on Senate Bill 253, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 666, please slowly state and spell your name for the record. You may begin.
Mr. Chairman, members of the committee, Warren Hardy, W-A-R-R-E-N, last name Hardy, H-A-R-D-Y, calling in today on behalf of the Urban Consortium, which is made up of the cities of Las Vegas, Reno, Henderson, and Sparks. We initially had concerns with this legislation with regard to how they might impact our current processes for what was described by one of the testifiers as nuisance alarms. However, we've spent some time working with and having conversations with the proponents and have explained to them our process for dealing with these nuisance alarms. And excuse me, and we are assured by them that there is nothing in this legislation that would interfere with our efforts and our current processes for dealing with these. So we are in a neutral position on the legislation, and we'll continue our current processes. So thank you for that opportunity to get that on the record, Mr. Chair.
And thank you for joining us this morning. We'll stay on the phone lines just to make sure that we don't have anybody else on the neutral position. Next caller, please, broadcast.
Chair, there are no more callers in the neutral position at this time.
Great. At this time, Senator, any closing remarks you may have?
Thank you, Chairman Flores and Committee of Government Affairs. I appreciate your time in hearing Senate Bill 253 today, seeking to change the behavior of these matters. Kind of funny, Mr. Taylor back there, he's changed my behavior on agricultural burns in the past when he was with East Fork Fire Protection District and had some discussions with me about some things I was doing improperly. But that's what we're after. We're trying to change behaviors. And more importantly, reduce the number of nuisance alarms that are going on. And we feel that this language and this bill will do just that. It'll make sure that the proper people are the ones that will actually change their behavior by making sure that they are the ones that get the fine. with that, I appreciate your time. If you have any concerns or issues, please do not hesitate to reach out to me, and I'll try to address them as quickly as possible. Thank you, Chairman.
And again, thank you. With that, we'll go ahead and close out the hearing on Senate Bill 253. Members, make sure you reach out should any additional questions arise. Lastly, on the agenda, we have public comment. I want to remind those of you wishing to speak during public comment that this is not a time to reopen a hearing, but rather to speak on general matters that fall within the purview of this committee. Broadcast, please, if we could go to the phone lines for public comment.
To take place in the public comment queue, please press star 9 now. Chair, the public line is open and working, but there are no callers at this time.
Thank you. Members, I want to remind you that tomorrow we'll be meeting again at 9 a.m. And we have Senate Bill 150 and Senate Bill 254. Please give yourself an opportunity to speak to all folk involved in that conversation. I know some of these bills do have some opposition and support. Give yourself an opportunity to become familiar with that and engage in that conversation ahead of time. With that, members, before we adjourn, I will say happy Cinco de Mayo, and I hope that we can all get together later on tonight. With that, this meeting's adjourned.